Our next speaker is Professor Lawrence Mitchell of George Washington University Law School. The topic of his talk will be, with a movie reference, Gentleman's Agreement, the Anti-Semitic Origins of Restrictions on Stockholder Litigation.
Thank you.
Larry, his expertise is in corporate law, and that's part of the reason for this paper.
Right, I'm the odd man out here. Thank you, Mark. Thank you, Suzanne. My offering today is rather modest compared with some of the wonderful and richly woven theoretical and historical insights that we've been privileged to share over the past couple of days. I'm going to take a single, simple, straightforward provision of the New York General Corporations Law, which was enacted in 1944, and try to demonstrate that the motive underlying its passage was deeply anti-Semitic and designed to put a large segment of the New York Jewish bar completely out of business. I will then, if time permits, suggest in a far more tentative way that the lingering shadow of Shylock hovered over Congress's enactment of the 1995 Securities Reform Act, which in its own turn attempted to shut down securities class actions, also the province of the Jewish bar. Lawyers may be, as Mark told us yesterday, the new Jews, but I will argue that a Jewish lawyer, at least in mid-century, was by other lawyers still a Jew. Section 61B of the New York General Corporation Act was passed in March 1944, only 2 weeks after its introduction in the New York State Legislature, and with less than 2 days of debate. The statute required that a derivative suit plaintiff who owned less than 5% of a corporation's stock had to post securities for expenses, including attorney's fees, in an amount of more than $575,000 in 2006 dollars. The statute was the product of a privately and voluntarily undertaken year-long study by the New York Chamber of Commerce, a non-governmental organization composed mostly of members drawn from large corporations and banks. The report was released for the first time together with the introduction of the bill, leaving no opportunity for reflection, refutation, or argument. By any measure of intellectual or scholarly integrity, the report's conclusions regarding the scourge of derivative suits in corporate America and the need to shut them down is so flawed as to question all of its conclusions. What is beyond question is that the business of representing plaintiffs in derivative suits was, as it remains today, largely a Jewish business. In 1944, the business of defending corporations and banking interests was indisputably the business of white Anglo-Saxon Protestants, the very same men who staffed those banks and corporations. Section 61B, enacted in an atmosphere of WASP status panic and heightened American anti-Semitism, was just designed to chase the Jews out. There's no doubt at the time, by the way, that the statute would accomplish this result. The Jewish lawyers representing derivative suit plaintiffs typically either were sole practitioners or worked in firms of 2 or 3 lawyers at the bottom of the legal financial ladder, earning a median annual income of less than $30,000 a year in 2006 dollars. That puts them, I believe, pretty close to the poverty line. In any event, the plaintiffs who owned the stock certainly couldn't finance these suits, and neither could their lawyers. It was only when judges of the New York Court of Appeals reversed lower court rulings and allowed potential plaintiffs to aggregate their stock in order to meet the securities for expense restrictions that the only method of restraining corporate executives' malfeasance was saved. Now, my story, of course, is circumstantial. I couldn't find a document anywhere that reveals an insidious plot to push Jewish lawyers out of business. So a lot of evidence lies in the statistical data. Rather than distract you with slides, and besides, I don't know how to use PowerPoint, I'll summarize the data which I present in far more detail in the paper and tell sort of a more general story from it, although I can't really compete with Sam's anti-Semitism stories, at least in color. So to set the context, in 1944, the year of the statute's enactment, was interestingly probably the apex of American anti-Semitism. The apex, of course, because 1944 was the year before European Jewry had been completely wiped out. polling data show this. We don't know as much about the era before polls were kept, but of course Jews were less a presence in daily American life earlier in the 20th century than they were by the 1940s. And this kind of polling data may have a significant likelihood of underreporting because even then the racist answers were slightly unattractive. So the numbers, which are pretty striking in and of themselves, may be even more striking than they appear. So just for a few statistics, in May 1938, 36% of respondents agreed that Jews had too much power in America. In 1945, 58% of Americans agreed with this statement, despite the fact that the annihilation of European Jewry was then well known. In 1941, Charles Lindbergh gave his famous Des Moines speech for the America First Committee. Lindy, of course, was well-educated. His dad in Congress in 1917 introduced a resolution to impeach the entire Federal Reserve Board as an international Jewish banking conspiracy. So Lindbergh gave his speech and accused three groups of drawing Americans into the war: Jews, the Rose Nation, and the British. Later that year, 40% of the survey respondents remembered the accusation against Jews, 31% against the Roosevelt administration, and 21% against the British. In June 1944, 24% of respondents identified Jews as the greatest menace to America, compared with 9% accusing the Japanese and only 6% accusing the Germans. In 1940, 46% of respondents claimed to have heard negative comments about Jews in the preceding 6 months. In 1946, the year after the war ended, still 34% had. There's some more data. I don't want to take too much time with this. One of my favorite is the 1942 survey, who asked high school students who would be their last choice as roommates. We joined with the African Americans, who scored 78%. We came in at 45%. So in any event, I just to wrap this up, and I'm indulging myself a little bit, but the article is just too precious for me not to share. I'd like to talk about a 1955 article in Look magazine entitled "The Position of Jews in America Today." The author, who was actually quite sympathetic to American Jews, could still ask such questions revealing ancient anti-Semitic saws as, why are there so many Jewish organizations? Having presumably not read Tocqueville, and what makes Jews so clannish? He could make such affirmative statements as Jews do tend to be clannish. For centuries, the Jews were misfits. Some Jews tend to be over-aggressive. A great many are hypersensitive in their relations with Gentiles. And perhaps most astonishing of all, and apparently as evidence of this last statement, they seem to have a special exposed nerve that registers every tremor of prejudice like a seismograph. So you see, this is all biological. And what proves our hypersensitivity is let a Gentile use an idiomatic phrase like, he Jewed me down, and every Jew within earshot will mark him as a bigot. We are an oversensitive people. Anyway.